May it please the Court. My name is John Albano. I'm here on behalf of Globe Newspaper Company. The parties to this case are in agreement on at least some of the issues implicated by the Superior Court's decision. All of the parties on briefs agree that the 1992 amendment to Chapter 38 means that with respect to inquest transcripts, the statutory mandatory impoundment period ends upon the return of an indictment. The defendant and the Globe agree that the same rule applies to inquest reports, though the Attorney General's office takes a different position. The position that it does apply to inquest reports is consistent with the District Court Department's publication on the rules for inquest proceedings.
Before you go too far along those lines, imagine there to be a report as well as a transcript, an indictment issues as it did in this case. Press learns about it before anybody files a motion to impound. Immediately made available to the press upon the release of the indictment. There's no period of time to allow the court to decide whether or not to wait for a motion to impound?
The request would still, if I follow the hypothetical, Your Honor, the request would still have to be made to a superior court, and just as with the case of the transcript, in both situations, the request is made, and the Globe's position is that the superior court retains all of the power it always has to grant or deny a motion to impound, to grant or deny a motion to lift that impoundment order consistent with common law principles.
But I didn't understand your brief to essentially espouse the position you're taking now. I thought that your position was that the impoundment expired immediately, automatically, upon the issuance of criminal process. And that would entitle the Globe to walk into the clerk's office and say, I'm here, I want a copy of the report. End of story.
Which is very similar, Your Honor, to the situation when requests are made for jury lists. There is never, in my experience, a pre-existing impoundment order. A request is made for the jury list.
So you don't have to go to a superior court judge and ask, at least in your view, you don't have to request that a judge authorize you to see the report.
As a practical matter, Your Honor, that is exactly what happens in virtually all requests for access. Again, to go back to the jury list, no impoundment. I go in and I say, I would like a copy of the jury list.
But you want us to say that the impoundment order expires, and that the Globe anybody is entitled to walk into the clerk's office and obtain a copy of a public document.
And that is the rule for all documents on file with the court. It is the rule for search warrant affidavits that this court affirmed in the Republican. Exactly same position.
Yeah, but the statute there says that it is a public document, doesn't it?
The statute there is quite similar. It says it's sealed until it's filed with the court.
As a practical matter, just to go back to the jury list, and it may be the Republican, one of the cases involved the court saying, no, I'm not, for particular reasons, I'm not going to release the jury list. So walk me through how that happened. In other words, Globe goes in, there's no impoundment order to begin with. Somehow it didn't get released to the Globe. So I'm just wondering whether that same process would operate here.
This happens literally every time I've been involved in a request for a search warrant affidavit, a jury list. There is never, almost never, a pre-existing impoundment order, and never am I or any other litigant able to say, don't tell the judge, it's presumptively open, I get it now. The way it works with respect to all of these judicial records is a request is made, it goes to the judge either says I'm going to impoundment or makes no impoundment order, but just holds it until there's a hearing on the request. And it would be, I would say, and I'm not aware of any litigant in the Commonwealth that's argued, oh, judicial error. The judge was not entitled to apply the rules, the common law rules, to determine if this document, whether it's an inquest report, a search warrant affidavit, or a jury list, error for the judge to say, before I release it, I am going to.
Sua sponte, without a request for
It
impoundment.
happens regularly. And
Just
I mean,
wanted
let
to
me go a
clarify
little-
your view.
Yes, it would be a bit frivolous, I think, for me or anyone else to stand up to say, there's judicial error. It was presumptively public. There was no impoundment order with findings to support them, and they didn't give it to me. They later made findings that supported the impoundment order, but that shouldn't count. I should have gotten it immediately.
I take it you would be satisfied if there were some kind of intervening temporary impoundment order until people had a chance to express their views, you could live with that.
Absolutely, because, again, as I've said, I don't see that as different in principle from the reality that exists in the Commonwealth today.
Does a prosecutor have an ethical obligation to file a motion for temporary impoundment? Rule 3.6 says that, I take it, that a prosecutor could not, at the close of an impoundment proceeding and upon the institution of criminal proceedings, a prosecutor couldn't get up and read what's in an impoundment report or in an inquest report to the press, could he? Without violating Rule 3.6, it contains materials that he's not allowed to report, to state publicly.
I think there's two issues there. One is whether, I don't know whether the prosecutor is required to, but if the prosecutor is concerned about the disclosure, I think it would certainly be wise to file an impoundment motion. I think there is here I think there can potentially be a distinction between impoundment orders and what is colloquially called gag orders. But in the case of prosecutors, there are special responsibilities in certain cases. I grant you that. But an impoundment order, I think, although this has nothing to do with the issue presented here, I do think that if the court was faced with an issue of does an impoundment order by its terms restrict speech about what is impounded, that raises, I think, some different, more subtle issues that have nothing to do with this case. But I do think those issues exist. In general, again, not wise, I would say, and well, let me go further, pretty high risk for someone to be reading aloud from an impounded document.
With respect to whether there is or is not a difference between the report and the transcript, clearly there's a difference in the statute post-92 amendment.
Well, I won't pretend that I knew this before, but in preparing for this argument, I found a case that Justice Holmes decided when he was on the circuit court in 1908. He was talking about how to interpret statutes, and he said, "It is not an adequate discharge of duty for courts to say, we see what you are driving at, but you have not said it, and therefore we shall go on as before." I think that applies here. There clearly was an intent by the legislature to change the rules on public access to inquest materials. There is no mention in the statute of impounding inquest reports at all, so I see no statutory requirement. And if
But
I
I
could
thought
go,
we said it was a common law requirement.
It's
And
just-
so- but the statute has not clearly preempted the common law with respect to the report.
the statute has, I think there's a statutory issue and there's a common law issue. My position is the best reading of the statute is what in the world would the legislature be doing saying we're going to make the inquest report public upon indictment, changing the rules of Kennedy. We will make no mention at all of the inquest report. And the statutory scheme we are setting up is we are trusting trial court judges to apply the common law to protect the defendant's fair trial rights when it comes to the inquest transcript. But we certainly cannot trust them to apply the common law when it comes with the inquest report. We need to take that power away from them and make sure it stays subject to a mandatory impoundment. I do not believe at a threshold level that that is the best reading or the proper reading of the statute. But in the end, it doesn't really matter because the Attorney General's position, as I understand it, is that what the legislature did was leave that part of the Kennedy rule intact.
Right.
the common law rule. And so now it's for this court to decide, should the common law develop in light of this significant statutory change? Should the common law recognize that given the nature of an inquest report and given the fact that the trial court will be deciding, as the trial courts are always trusted to do, whether the inquest transcript will be released, should we, as a matter of common law, take that power away from the trial court when it comes to the inquest report?
Your time is up.
Oh, could I just ask one question?
Sure.
What do you say to the argument that, you say this needs to be remanded for findings or not at all, but what do you say to the argument that embedded in Judge Donovan's decision are findings about why impoundment is appropriate here?
There are three supposed findings. The first two are the documents haven't yet been released and there may be a trial. Those aren't findings that support an impoundment order. They're present in every case. Third one is fair trial rights. The extraordinary part of that aspect of the ruling, which is in a footnote, is that what the court is saying is, forget about Toolman, decided a couple of weeks ago by this court, where the 10,000 people in Nantucket were not subject to presumptive prejudice. This court says Norfolk County, which has about 65 times more people than Nantucket, not just Norfolk County, the entire Commonwealth of Massachusetts will be poisoned, and the defendant will be unable to get a trial if the report and the transcript are released. There are not sufficient, there are no findings that support that kind of statement, and the relief we request is, given that this court has the report, the transcript, and the lower court decision, we ask that it not be remanded for further findings. The motion was filed in June 2010. We're in September 2011. A remand would mean undoubtedly another appeal, that the whole purpose underlying the common law right of access would be subverted by that kind of a delay.
But you've ignored the fact that she's facing the death penalty for a murder in a different state, and that whatever is released here would almost certainly be a matter of local news in Alabama with regard to that case.
I don't mean to ignore it, Your Honor. My position is that the standard is not, it seems to me respectfully, that the Superior Court, because of that significant interest, applied a standard of, will people have heard about the case or information about the case? And respectfully, that is not the standard. It is, will they not be able to set aside any preconceived notions and decide the case on the evidence? This court has said if 42% of the veneer is excluded for because of pretrial publicity, there's still no presumptive prejudice. So that standard can't be met no matter what jurisdiction she faces another trial in.
Mr. Albano, I know that we've talked about an inquest as a quasi-judicial proceeding, but historically, help me out, the coroner was not a judicial officer, was he or she? Wasn't he essentially an executive, an agent of the executive?
From the research, it indicates to me that initially it was non-judicial, non-medical, collecting taxes for the Crown, and it ultimately evolved into the position that we have today. But there is historical evidence that we have cited in our brief that these proceedings and these reports were not historically sacrosanct and secret. Thank you.
Good morning. My name is Larry Tipton. I represent Amy Bishop as an intervener. As we argued in our brief, what the narrow question here today is whether Judge Donovan abused her discretion in entering an impoundment order. The Globe argues repeatedly that Her Honor ignored the import of Section 10. In fact, her decision shows that she carefully thought about the issues being raised by all the parties at the hearing.
Do you think the judge had in mind that there should be a presumption that the transcripts, for example, are public?
I don't believe that's true, Judge.
Shouldn't there be such a presumption? The statute says.
It might be that there should be a presumption, but I think what the judge was thinking was, when confronted with the arguments and the request to disclose, was immediately took into account the reasoning in Kennedy and then the specific language of Section 10, and then immediately began to seize upon the possible prejudice, pretrial prejudice, to suspicion.
Does she really acknowledge that the reasoning in Kennedy, at least with respect to the transcripts, is simply no longer valid?
I don't think she does specifically acknowledge that in her memorandum of law. It's
Doesn't she see the statute as basically not affecting Kennedy's articulation of common law principles?
I don't believe that's true, Judge. I think that, I don't think that's accurate. I think what Judge Donovan wrote, and maybe not as artfully as she would have otherwise with the pressure of time, but she acknowledged that Section 10 did modify Kennedy, but she still carefully weighed the considerations that Kennedy made very clear. And I think it's important in this case to understand that what Judge Donovan was confronted with was similar to what the Kennedy court was confronted with. A very high media access. In that case, it's even demonstrated that Kennedy conducted his own press release, interviewed the press. So there was a lot of media attention to this. And even then, the Kennedy court saw fit to restrict access until certain triggering events happened. And I think that's what Justice Donovan was trying to address, that yes, Section 10 seems to alter the very some of the procedural requirements of Kennedy.
But under Kennedy, did a judge have discretion?
Before Kennedy, there was no guidance. After Kennedy, I believe there is some discretion.
But once a criminal, there's that little subparagraph 6. I forgot what section it's in Kennedy, and its proposed rules. It says that effectively that the impoundment will continue throughout the criminal proceedings until a verdict is rendered.
Well, it says that, but it also adds another triggering event if it doesn't seem like criminal prosecution is likely.
No. Here, criminal prosecution commenced. And under that little subparagraph 6 in the proposed rules, it seems to, if not implicitly, somewhere between implicitly and explicitly, it seems to say that that the impoundment will continue throughout the course of the criminal proceedings until a verdict is rendered.
Right, it does. And so I don't.
So it's automatic.
It's automatic.
In this day and age, does that make any sense?
Well, yes.
Without any kind of weighing as to whether it's prejudicial to the defendant?
Well, you mean automatic, that it be automatic that it remain impounded?
Yeah.
My answer would be yes, it makes sense that there would be no discretion, if that's what the case is, that there would be no discretion to release the inquest report until the case is over.
And the judge, I take it, in this case, shared that view, because it seems as though she thought she had no discretion.
I disagree respectfully, Judge. I think she believed she did have discretion, and so she made the implicit findings, although she doesn't caption them with the term findings, but she made implicit findings that there are issues here that flow from the reasoning of Kennedy that require continued impoundment, whether we say it began automatically by operation of statute or now there are further reasons to continue the original impoundment order. I believe she did exercise her discretion and made those implicit findings. Otherwise, she wouldn't have needed to even write her memorandum and her opinion and articulate those implicit findings and address some of the arguments that Amy Bishop made, for instance, the public records exception to Chapter 4. She carefully thought through all of these things, and I think in that vein, she is demonstrating that she is, in effect, exercising her discretion. I would rely on the brief as we argue that we do believe and we continue to hold that this extraordinary relief is inappropriate at this stage of the case, that in fact the Globe had other options, that the Globe could have filed a civil proceeding under Ottawa and gone through the normal course instead of evoking the superintendent's powers of this court. Also, while we do believe that Judge Volterra's decision, his trial court decision in Walton, is correct reasoning, we'd also note that the Attorney General also took that position before, and that is that the inquest report and the transcript, and for that matter, the exhibits of any inquest, are all tied together. That the statute is inartfully drawn, that it refers to the transcript and not the report to be impounded. But we do hold and we do argue the position that in this case, Judge Donovan both found that continued impoundment was warranted given the enormous prejudice that would flow to Amy Bishop, given the fact, as Justice Gantz has pointed out, that she faces the death penalty, which has been announced in Alabama. She does, in fact, face the death penalty, and she faces a murder indictment in this state.
Can you just, as a practical matter, where do the two prosecutions stand temporally? Two sets of things.
The Alabama procedure right now is still going through the discovery and pretrial process. There has been an announcement by the district attorney that he will be seeking the death penalty. Other than that, but
there's no trial date set.
There's no trial date set.
And are they going to be tried all together? Is that currently the plan?
I can't speak to that, Judge. There is a gag order. I've had some limited conversation with the Alabama attorneys. I know that in fairness to Amy Bishop in Alabama, the court has sealed the documents but still allowed that the pretrial hearings be public, but the documents are in fact sealed.
Do they have a copy of the inquest report down there?
They do not.
No.
They do not.
Have they asked for one?
They did, and did not ask for it formally, but given Judge Donovan's ruling and given her opinion, they chose not to seek it. With that, I would.
Thank you, Counsel.
Good morning. May it please the Court. Assistant Attorney General Natalie Monroe on behalf of the Attorney General's Office. And with me at counsel table is my colleague Todd Bloom. All of the parties agree that the transcript is governed by Chapter 38, and it is the Attorney General's position that the report is governed by the Kennedy decision. First, this Court has repeatedly held that when the legislature amends a statute, it is presumed to be aware of this Court's prior interpretations of that statute. And when the legislature reenacts language without any material change, it is presumed to have adopted this Court's interpretation of the statute. Here, in 1969, this Court held in Kennedy that the inquest report must remain impounded until after the criminal trial of the individual identified as responsible for the death at issue, or until it appears likely that no such criminal trial will take place.
I'm sorry, let me just be clear as to what you're saying. Are you saying that the absence of any language with regard to the report means that it's governed by the common law, or you mean that we should view the legislature as having adopted the Kennedy decision as essentially a part of the statute?
I think that the legislature, because it did not address it, has essentially adopted that language in the statute.
So you're saying we should basically view Kennedy essentially being off limits for our review because the legislature has adopted it, and we should treat it as if there's language in the statute that adopts the Kennedy holding?
That may be going too far. I would certainly say that in interpreting the statute, the interpretation that the Boston Globe and CPCS advance is not supported by this Court's rules of statutory construction, in that in the absence of a change in the statute, this Court's prior rulings remain in place.
Aren't you really saying that the legislature picked one piece of it, changed it, left the rest in place, and it would be up to us to change or not change as a matter of common law?
That is accurate, yes. And it's important to realize in this case, just as you noted, that when the legislature overhauled Section 10 and Section 8 of Chapter 38 in 1992, it made many changes, but it also did not address many different issues. For instance, in Kennedy, this Court held that the district attorney, the attorney general, and the person identified in the report as responsible for the death had the right to review the impounded report while it is impounded. If the CPCS and Boston Globe's interpretation is adopted, that rule would be wiped out. It would be, because the legislature didn't address that in the 1992 revisions. Under their reasoning, that would no longer exist, and the DA, the AG, and the person identified as responsible would no longer have the right to review the impounded report. I would also say that there's very good reason for treating the inquest report and the inquest transcript differently. The transcript contains the testimony, the raw evidence, if you will, and public citizens can read the transcripts for themselves and reach their own conclusions. However, the inquest report contains the judge's conclusions, including her evaluations of the credibility of witnesses and her treatment and weight that she gives to various pieces of evidence.
Can I ask you a question?
Yes.
Is there anything other than a report and a transcript? I mean, are there documents or other things that go into evidence?
There, depending on the inquest, yes. There
What
may be
about
exhibits.
those?
The Globe is not seeking the exhibits in this case.
No, I understand that, but how does the Kennedy / statutory scheme affect those?
The statutory scheme the statute does not address exhibits, and under Kennedy, the exhibits would remain impounded until after the criminal trial is completed.
So the exhibits stand on the same footing as the report. And is there as good a reason to keep the exhibits impounded as there is on your analysis to keep the report impounded?
No, I do believe that the exhibits should be subject to a good cause analysis at the time that the indictment is returned.
Okay, how does that follow from the statutory analysis that you were just giving?
If this court is interested in reviewing Kennedy, then it would be appropriate for them to. Even though this is not an issue that was addressed in this case,
No, I
I just mean in
understand.
general, if the court would have the authority to.
As a matter of
overrule.
common law.
Correct. As a matter of common law, would have the authority.
I suppose exhibits are sort of, I mean, they're the evidence. They're the physical evidence.
Correct.
The transcripts are the oral evidence, and one could interpret the statute to suggest that the evidence is what the legislature had in mind that could be released once there's been an indictment.
Certainly, certainly.
Do you agree, well, you obviously don't, why don't you agree with Mr. Tipton that the judge, with respect to, let's just take the transcript, with respect to the transcript, the judge made adequate findings to justify, because Amy Bishop did move for impoundment, to justify the impoundment of the transcript?
With all due respect to Mr. Tipton, a fair reading of the judge's decision makes it clear that what she did was review the two cases that the Globe cited in support of its motion to unimpound the documents, Republican Company and Sharp, and concluded that neither of those two cases governed this case. And then she concluded by stating that the uniform rules of impoundment did not apply, and this is on page 26 of the record appendix. Here, I'm quoting, here the impoundment is required by statute, GL Chapter 38, Section 10, and not by court rules. The statute does not impose upon the court to make the requisite findings required by the rules. The impoundment is automatic. That she then does go on and discuss Ms. Bishop's argument that the public records law also prevents disclosure. But that is her ruling, and there's no fair reading of this case to say that 3 observations in a footnote were actually finding of good cause. And with all due respect to the judge, if she meant that to be a good cause finding, which I state is which I posit is not what her intent was, it's not adequate. It is not an adequate good cause finding. She did not, for example, balance all the competing interests at issue. She did not consider the fact that there's been a lot of publicity in her case already, and that the DA had released a significant amount of information. She did not consider all of the alternatives to impoundment, and she did not make written findings that good cause exists. You will not find that language in her decision.
But Mr. Tipton suggests it was implicit in her findings.
I just, very respectfully, I don't think a fair reading of those 2 footnotes that he's referring to, or her very clear language that the impoundment is automatic, and this court is not required to make the requisite findings under the Uniform Rules of Impoundment Procedure, I don't believe a fair reading of that language can be interpreted to be a finding that good cause exists.
And do you think that we should do that, or do you agree with Mr. Albano, or do you think that it should be remanded if we agree with your interpretation of the statute?
I think it should be remanded. I think that this court has held repeatedly, including in Sharp, that the trial court is in the best position to make that analysis. With respect, one point with respect to Walton, the Attorney General's position in this case is identical to the position it took in that case. In that case, the grand jury had returned a no bill, and therefore the Attorney General's position was, under Kennedy, once a no bill is returned, the inquest report is no longer mandatorily impounded, and under Chapter 38, the transcript is no longer statutorily impounded. That is exactly the same position that the Attorney General has taken in this case. The issue in that case actually was more to do with the release of the inquest exhibits than the report or the report of the transcript. And very briefly, with respect to the alternatives, the Attorney General states that there are two very good alternatives to Rule 211.3. A person seeking inquest materials can either file a civil action or can seek relief under Rule 11 of the Uniform Rules on Impoundment Procedure. The Attorney General respectfully suggests that if the court adopts one or both of those alternatives, it consider, as it did in Commonwealth versus Silva, requiring the plaintiff to give notice to the Attorney General. The Attorney General believes, as the court found in Commonwealth versus Silva, that it is in the best position to represent the public interest in cases such as this. The Attorney General recognizes that there are many competing public interests. For example, the public's need for open government.
I don't understand. You've got the district attorney involved.
Right.
Why would you need the Attorney General's office involved in a run-of-the-mill, mundane question about, the disclosure of a document or whether it should be impounded? I mean, that seems fairly remote. The statute's not being challenged.
Oftentimes, it is not a mundane issue of releasing information.
Well, I mean, courts are faced with this every day. Should they not impound? Should they release? I mean, this is not exotic by any means.
With all due respect, we found in cases involving the release of juror names, as that was the issue in Commonwealth versus Silva, the district attorney does not always have the same interests as the public interest. The Attorney General's job is, the district attorney's role in those cases is as the prosecutor.
Yeah, but here he's the one that he mandated. He didn't even demand or request. He mandated the inquest. It's his property in some respects, isn't it?
Well,
no.
Well, Silva says, Silva, unless we change the rule in Silva, the Attorney General represents the court in these matters, right? Isn't that what Silva says? That when there's an impoundment order and the court is ordered, whichever way it's ordered, that the Attorney General is to represent the court because you've got two competing interests on the other side.
What Silva says is that you're absolutely correct that in Silva, the Attorney General appeared on behalf of the court, and in Silva, the court made it clear that the party seeking release of impounded information in a criminal matter, whether closed or open, must give the Attorney General notice and an opportunity to be heard. And the court said that the reason for that is that the Attorney General's office was in the best position to represent the public interest. Now, in some instances, this court is absolutely right. It may not warrant the Attorney General's involvement, but in other instances, such as this one, it does warrant the...
Does a prosecutor have an ethical obligation to at least seek temporary impoundment of the inquest report or the inquest transcript and report?
I agree with the Globe that in most instances the courts do not release previously impounded documents without holding a hearing. To the extent that that's not the case, I think it would be important for the court. The court could take this opportunity to clarify that should be the rule. Otherwise, there will be a lot of unnecessary pre-litigation or defensive litigation seeking impoundment, not only by the district attorney, but by witnesses or the target of the investigation. And And in those instances, it's very likely that the media would not even be present. So you're asking for basically two hearings. One is the impoundment hearing that's ex parte without the press there, and then a motion to lift the impoundment.
Thank you, counsel.
Thank you.